Hey y'all. Let me know. I'm starting to see some comments here. Let me know if y'all can see me and hear me well. We have huge, absolutely stunning breaking news out of California when it comes to the Second Amendment. I'm trying to do about 93 things at once here, but it appears as though we are live. Give me one momento while I get this decision queued up for y'all. We're going to go over some cool stuff here. We're going to go over some cool stuff. Okay, I'm going to try if I can get this to share my screen window. And I think we're good here. All right. So I want to draw your attention to this screen. Come on. Share. Boom. Okay. Actually, let me see if I can blow that up for you. Wee. All right, so what we're going to talk about here is a huge case that's been going on for almost a year. And this case is Reno May, who we all know and love here in the Second Amendment on YouTube, Anthony Miranda, the armed scholar, Eric Hans, Gary Brennan, Oscar Barreto Jr., Isabel Barreto, Barry Barami, Pete Stevenson, Andrew Harms, Jose Flores, Dr. Sheldon Huff. I'm about to sneeze. Dr. Huff is a dentist. The Second Amendment Foundation, Gun Owners of America, Gun Owners Foundation, Gun Owners of California, Liberal Gun Owners Association, and the California Rifle and Pistol Association, Inc. versus Rob Bonta, the crooked criminal-like Attorney General of California. Now that we got that out of the way, this is the original filing. This was no, is this the original filing? Maybe it wasn't a year. I don't know. Everything's been going on for so long. I'm going to show you the quick part, and then we're going to get into the meat and potatoes, because the meat and potatoes, chef's kiss, freedom chef's kiss. Wow. So this is a preliminary injunction that just came out against California's sensitive places, and the one pager from the judge is the easy part, and I'm going to try to. Excuse me while I'm looking to this screen over here. It says, this matter came before the court on the plaintiff's motions for a preliminary injunction. On December 20th of 23, the court issued an order determining that the challenge provisions of Senate Bill 2 are unconstitutional and granting a preliminary injunction enjoining enforcement of those provisions. Now, therefore, it is hereby ordered that the defendant Attorney General Rob Bonta and his officers, agents, servants, employees, and attorneys, and those persons in active concert or participation with him, and those duly sworn state peace officers and federal law enforcement officers who gain knowledge of this injunction order are or know of the existence of this injunction order are hereby preliminarily restrained and enjoined, meaning they can't enforce California Penal Code and all these sections. We're going to show you what these sections are. 7, 8, 9, 10, 11, 12, 13, 15, 16, 17, 19, 20, 22, 23, and 26 against any individual with permits to carry a concealed weapon issued under the California Penal Code sections, blah, 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 blah. Judge Cormac J. Carney, U.S. District Court Judge. This judge just kicked California in the teeth. I just got this ruling, thanks to both of those folks who sent them to me, GOA and Second Amendment Foundation. Let's get into this, because what the judge says here is really, really good. I'm going to move this. If I do this, will it blow it up? No. Okay, cool. So let's get into the judge's introduction here. It says, we live in dangerous times. Let me blow this up for you a little more here. We live in dangerous times. Nearly every day, we are barraged with stories about school shootings, attacks on places of worship, and other unthinkable acts of violence and cruelty. Nor are our society's problems limited to those acute facts of terror. Daily, our country faces prejudice and division of all types, economic uncertainty and poverty, a nationwide mental health crisis, and an epidemic of addiction and crime. The only hope to find in the face of such dire circumstances is that democracy, as it has up to this point, will prevail and somehow solve the challenges we face. But such hope is little comfort to individuals who, through no fault of their own, find themselves beset by an attacker and facing their death or that of their loved ones. Ooh, we have a based judge in California who's not named Roger T. Benitez. Ooh. The right to self-defense and to defend one's family is fundamental and inherent to our very humanity, irrespective of any formal codification. In their wisdom, the founders recognized the need for individual citizens to protect themselves and their loved ones from those that would do them harm. And they knew that such a right could not be vindicated without the right to bear arms. The Second Amendment to the United States Constitution guarantees law-abiding, responsible citizens the right to keep and bear arms for self-defense in case of confrontation. Please smash that like button. Please share this video. Please subscribe to the channel. It really, really helps me do what I'm doing. Thank you for being here. Let's continue. For many years, the right to bear arms, and so necessarily the right to self-defense, was regulated to second-class status. But the United States Supreme Court made clear in its landmark decisions, District of Columbia v. Heller, McDonald v. City of Chicago, and New York State Rifle and Pistol Association Incorporated versus Bruin, that relegation could no longer be permitted. Individuals must be able to effectuate their right to self-defense by, if they so choose, responsibly bearing arms. Some disagree with the founders and the Supreme Court that individual citizens have a right to protect themselves and believe that the best solution to the many dangers of the modern day is to prevent law-abiding citizens from carrying handguns. It is not this court's place to question their judgment as to how to solve the many challenges we face. That is up to the people and their elected representatives. But the Constitution, by design, recognizes that some rights are so important and sacrosanct that nothing short of the constitutional amendment may take them away. No one, not a federal judge, not a state governor or legislator, not even the president of the United States, is above the Constitution. I like this judge. I like him a lot. Nevertheless, I have a candle burning and I'm allergic to it. Sorry. Nevertheless, California recently passed a law, Senate Bill 2, that limits the public places where people with concealed carry permits may carry their handguns to defend themselves and their families. To obtain such a permit in California, a person must go through a rigorous screening process. The process includes a lengthy application, a thorough background check involving interviews, fingerprinting, and reviewing multiple government databases, and a full-day hands-on training course in which the person must demonstrate they can safely and proficiently use the handgun they seek to carry in public. Even with those stringent requirements, California will not allow concealed carry permit holders to effectively practice what the Second Amendment promises. SB 2's coverage is sweeping, repugnant to the Second Amendment, and openly defiant of the Supreme Court. The law designates 26 categories of places, such as hospitals, public transportation, places that sell liquor for on-site consumption, playgrounds, parks, casinos, stadiums, libraries, amusement parks, zoos, places of worship, and banks as sensitive places, where concealed carry permit holders cannot carry their handguns. SB 2 turns nearly every public place in California into a sensitive place. And this is happening in other states as well, effectively abolishing the Second Amendment rights of law-abiding and exceptionally qualified citizens to be armed and to defend themselves in public. Plaintiffs who are concealed carry permit holders and related organizations brought these two lawsuits against California to challenge the constitutionality of many of SB 2's sensitive place provisions. They now seek a preliminary injunction enjoining California from enforcing the challenge sensitive place provisions, asserting that many of those restrictions violate their Second Amendment rights and deprive them of their ability to defend themselves and their loved ones in public. Plaintiffs are right. Their motions for a preliminary injunction are granted. Hoo-wee! And my phone is blowing up. Y'all, thank you to Reno. Thank you to Anthony and everybody else who put their name on this. Y'all did it. You put your name out there for the people of your state, and you have pulled in a preliminary injunction a victory in the short term. We know that, California is going to appeal this. We know this. We'll see what this judge does, if he's going to put a stay on this. But I want to get down to this part here. Blah, 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 blah. You'll have to excuse me for the scrolling. Okay, finally, SB 2 provides that a person granted a concealed carry license shall not carry a firearm on or into 26 categories of places. Plaintiffs in these cases are 14 ordinary law-abiding citizens with active concealed carry licenses and 10 organizations whose members have such licenses who want to be able to continue to carry concealed weapons at places they carried them before to protect themselves and their families. They challenged SB 2's provisions prohibiting CCW permit holders from carrying in the following locations. 7 is hospitals, mental health facilities, nursing homes, medical offices, urgent care facilities, and other places where medical services are customarily provided. 8, public transportation. 9, establishments where intoxicating liquor is sold for consumption on premises. 10, public gathering and special events, playgrounds and private youth centers, parks and athletic facilities, Department of Parks and Recreation, and Department of Fish and Wildlife property, except hunting areas. Think you'd need a gun in a hunting area? I'm just saying. 15, casinos and gambling establishments, stadiums and arenas, public libraries, amusement parks, zoos and museums, churches, synagogues, mosques, and other places of worship, financial institutions. And 26, any other privately owned commercial establishment that is open to the public unless the operator clearly and conspicuously posts a sign indicating that license holders are permitted to carry firearms on the property. That is an exact flip of the way things had always been. Private property owners have the option of stopping people from carrying on their property, not the other way around. They also seek to enjoin SB 2 to the extent it makes any parking areas a sensitive place. We've seen that in a few states as of late as well. Then it goes into the fact that a preliminary injunction is something that's serious. It says the plaintiffs are likely to succeed on the merits of their claim that the challenged SB 2 violates the Second Amendment. It goes into what the Second Amendment says. Then goes into Bruin's text, history, and tradition. Blah, 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 blah. Government does not appear to dispute that step 1 is met, except as section. That means, the Bruin text, history, and tradition. Let's see. This is awesome, guys. This is a humongo win. Again, hit the like button, please. Share the video and subscribe to the channel. I lost a couple hundred subscribers here in the last couple days. I think I know one of the reasons why, and let's see if we can rectify that, guys and gals. Here we go. Let's see that other part I wanted to show you. I'm going to minimize this a little bit so it's easier for me. Okay, it talks about all the spots that we just detailed. We just talked about, but it goes into it in great detail. Let me actually bring that off screen for a moment so that I don't blind you with all this constant scrolling. And I will get down to the last part here. All right, we'll go down to this part here, which is the judge's conclusion. And come back on the screen, doctor. Boom. Says the Second Amendment preserves a fundamental constitutional right for law-abiding citizens to keep and bear arms for self-defense. Increasingly in modern times, with the ubiquity of guns and our country's high level of gun violence, ordinary law-abiding people feel a need to carry handguns in public to protect themselves and their families against violence. This may be because they live in high-crime neighborhoods, or because they must traverse dark and dangerous streets in order to reach their homes after work or other evening activities, or because they reasonably believe that unless they can brandish it, or if necessary, use a handgun in the case of an attack, they may be murdered, raped, or suffer some other serious injury. CCW permit holders are among the most responsible, reliable law-abiding citizens. They have been through a vigorous vetting and training process following their application to carry a concealed handgun. The challenged SB 2 provisions unconstitutionally deprive this group of their constitutional right to carry a handgun in public for self-defense. Therefore, those provisions must be preliminarily enjoined. Again, Judge Cormac T. Carney. And this is, like I said, breaking news. This has only been out for a short period of time here, and I wanted to jump on and share it with you all so that you can spread the word. Again, like the video, share the video if you think this is worthy of other people seeing it. If you don't, you are probably one of those anti-gun folks who watch my video, and I hope you enjoy taking this loss. Luther. So like the video, share, and subscribe down below. I know it's late. It is 9:15 here on the Eastern Seaboard. But y'all in California, you've been waiting for today. Just prepare yourself. This will probably be appealed. Like Bonta and that goofball Newsom, they do not take losses lightly. They will fight and fight and fight using your funds, your taxpayer monies, all the time, all the way through the entire process to try to take your constitutional right away. You're paying for them to take away or try to take away your right. That's how they play this game. Unlimited funds because we, the people, are paying for it. However, great work on those groups. I'm going to show you the folks again here because they all deserve a round of applause. Again, Reno May, Anthony Miranda, Eric Hans, Gary Brennan, Oscar Barreto Jr., Isabel Barreto, Barry Barami, Pete Stevenson, Andrew Harms, Jose Flores, Sheldon Huff, Second Amendment Foundation, Gun Owners of America, Gun Owners Foundation, Gun Owners of California, Liberal Gun Owners Association, and California Rifle and Pistol Association. Join those groups. Support those who support you. I say it all the time. Many of you do it. If you are members already, because you have done that, skip a pizza this week and send them another $20, $25 because it helps. It goes a very, very long way. With that said, I will let y'all back to your evening. Again, thank you to all of my friends in those groups. Thank you to my friends Reno May and Anthony Miranda for doing what y'all have been doing. The job is not done. I know there will be another step or two, but we're behind you. And appreciate y'all. Be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. I will see you on the next one. Take care, y'all. Have a phenomenal night. And always tell the ones that you love them. You're never going to know when you're getting a second chance, y'all. Take care.